claim to be destabilizing regional relations, rather than those who have been perpetrating human rights violations. Although many of the individuals targeted for destabilization, these individuals have also been found to be complicit in domestic human rights abuses, but this has not been necessarily reflected in the designation statement. Now, all of this is not to say that Magnitsky-style sanctions are a cure-all or that their application is without flaws. Quite far from it. There are significant shortcomings, and by way of conclusion, I'll address a few ways of how we can mitigate those. First, for Magnitsky-style sanctions to be as effective as possible, they need to be imposed in coordination with international partners. Such coordinated action is particularly crucial to prevent sanctions individuals from exploiting loopholes. Only a unified approach sends a strong message that impunity for human rights violations in Iran will not be tolerated. Second, these designations must be based on solid evidence from survivors. This process must be transparent with clear justifications for each designation while engaging civil society organizations to enhance their effectiveness. What this effectively means is that government need to effectively collaborate with civil society organizations, take the evidence seriously, and ask for their feedback on designations. Civil society organizations often possess critical insights into the broader context of abuses and the networks of perpetrators. This can help make targeted sanctions more legitimate and more effective in deterring human rights violations. Third, of course, sanctions must be applied fairly and impartially. This is especially crucial in the context of Iran, where concerns about Western double standards persist, meaning that any future designation must consistently be grounded in human rights consideration and be informed by survivors' experiences. These designations must also be accompanied by clear statements acknowledging officials' role in human rights violations, thereby creating a future record for accountability purpose. Finally, broader sanctions against Iran that are already in place must be regularly reviewed to ensure that they do not harm civilians. Without such reviews, Magnitsky-style sanctions, even when imposed, risk being part of a broader sanction regime that may be perceived unjust by local populations. This must be coupled by efforts of diplomatic missions in Geneva and New York to align their condemnations of Iran's widespread human rights violations with concrete actions at the national level. Now, I'll conclude by saying that when Magnitsky-style sanctions are used of a broader strategy, they can be a vital tool in holding Iran's regime accountable for human rights violations. And I think the impact they can have is best summarized in the statement that human rights activist for Iran obtained, who recently interviewed a political prisoner. He said, "It is a ray of hope for people like me who suffer under their reign. It may not change things overnight, but it shows us that the world hasn't turned a blind eye." Now, again, the statement aptly summarizes the accountability function sanction can serve, documenting human rights violations and acknowledging victim suffering. With that, I conclude my remarks, and thank you very much for your time.
Thank you, Natalia, for sharing your insights on the importance of Magnitsky-style sanctions. I'm going to hand it over now to our final speaker, which is Valerie Gabbard, co-director of Uprights and HRA's partner in the launch of today's report. Valerie has over a decade of experience as a legal advisor to the United Nations in international criminal law, humanitarian law, human rights law, and transitional justice. Before co-founding Upright, she also served on the UN International Commission of Inquiry for Mali and the team of international experts on the situation in Kasai, DRC, where she investigated international crimes and gross human rights violations. She previously worked as a legal officer at the ICTY and Rwanda and at the Extraordinary Chambers in the Courts of Cambodia. Today, Valerie will be discussing the feasibility, strengths, and limitation of various judicial and non-judicial pathways as outlined in the report. So I'm going to hand it over to Valerie.
Thank you, Julie, and good afternoon, everyone, or good morning, depending on your time zone. I'm really happy to be here side by side with human rights activists in Iran. strong partner who fit very well the mandate of Upright as an NGO, which mandate is to work in partnerships to advance international law. So that fit very well. Thanks for the very personal presentation, Julie, but also I'd like to say that this is teamwork within Pride, and not only my work. So I would like to thank my colleagues, even though I'm the public face today, and in particular my colleague Lee, who is here in the audience. We've went from specific to now. Maybe we will go a little bit more in general and discussing a little bit more what you can find in the guide that HRA is publishing today. So in fact, the two presentations that we just heard on the fact-finding missions and on the Magnitsky style sanctions are both two types of accountability pathways that you will find discussed in the guide. But now maybe I'll try to use this opportunity to give a little bit of a broader overview. The primary goal of the guide that we published today is to empower and support a broader audience of victims, human rights activists, civil society, and in fact any stakeholder interested in accountability in relation to the IRGC and Iran. It provides an overview of the existing judicial but also non-judicial pathway for pursuing accountability for serious human rights violation and international crime. What we try to achieve here is not a very, very technical document, but rather a guide designed to be accessible and ensuring that the audience can gain practical insights in order to better understand expectations from those pathways, as well as assisting with strategizing accountability efforts. Now, I'm not going to lie, pursuing accountability for IRGC conduct in Iran or outside of Iran is a challenge and not a small one. The first reason why accountability is a challenge in the context of Iran is the lack of domestic avenue, which was noted by the special rapporteur and also by the fact-finding missions in several instances. In reality, Iran bears the primary responsibility to address allegations of human rights violations committed in Iran or by IRGC members, but pursuing accountability in Iran right now is just not a viable option. I will not go into all the challenges, but the lack of judicial independence, the discriminatory legal framework are all instances that led to quasi-impunity for IRGC members in Iran. So while acknowledging this limitation within Iran, the guide proposed other pathways with a focus on victim-centered processes. There are judicial, quasi-judicial, and non-judicial pathways outside of Iran that can and should be pursued to promote justice for victims. Each of the pathways discussed in the guides have limitations and specific requirements that are clearly set out. And we also look into their feasibility or lack thereof under the present circumstances. It's not possible to present all the pathways that the guide explores. So I've just chosen here to briefly explore some judicial pathways to illustrate the approach chosen by the guide and on what you will be able to find in more details in the guide. So judicial pathways include national courts outside of Iran, the International Court of Justice, ICJ, I will refer to it, and the International Criminal Court, ICC. Judicial pathways are generally difficult to pursue, but in certain instances, they provide concrete and realizable outcomes. Finding by domestic or international courts is likely to be binding legal decisions, so like a very strong outcome. In contrast, recommendation by non-judicial pathways such as UN human rights body or truth-seeking initiative may be more accessible, but not likely to be as binding or strong. But even within the judicial pathway, challenge and feasibility can vary considerably. For instance, judicial pathways at the national level, outside of Iran, just to be clear, despite their complexity and challenges, appears to have a higher likelihood of success than international ones, like the ICJ and the ICC, for instance. So just to go a little bit into details into that, just to make it a little bit more concrete, one of the IRGC classic modus operandi is to commit violation and crimes targeting dissidents to the Iranian regime all over the world. That is very specific modus operandi of the IRGC that we've seen over the year all over the world. Obviously, states where this act takes place hold natural jurisdictions to investigate and prosecute those crimes under their own domestic law. This is classic territorial jurisdictions. And over the years, several countries prosecuted individuals connected to the IRGC for crimes committed in their own territory. One of the most emblematic cases is the 1994 MEA bombing in Buenos Aires, Argentina, for which Argentina highest criminal courts concluded that the Hezbollah, under IRGC direction and financings, was responsible for the bombing that resulted in 85 deaths and 300 deaths. Now, what about violations and crimes allegedly committed by the IRGC in Iran against Iranian citizens? Can they be prosecuted by other national courts? The short answer is yes, relying on extraterritorial jurisdictions and in particular universal jurisdictions. Universal jurisdictions recognize that some crimes are so grave that they concern the international community as a whole. You can name torture, crimes against humanity, and that they allow states to investigate and prosecute individuals regardless of where the crimes occurred and regardless of the nationality and so on. However, applying universal jurisdictions isn't automatic, as it depends on each country's domestic law. Moreover, it often requires the presence of the accused within the country in question. And even when all the legal thresholds are met, there is a lot of political challenges, prosecutorial discretion that can act as barriers for us. So, that being said, in 2022, Sweden convicted Iranian official Haim Nouri for war crimes tied into the 1988 prison massacre in Iran, sentencing him to life prison. Although later returned to Iran in a classic prisoner's war, the case remains a landmark for universal jurisdictions in relation to Iran. And there's another case that is under investigations in the UK, open in 2024. Even though those cases do not concern directly IRGC members, they concern Iranian officials, and they show that accountability for crimes committed in Iran can be pursued through universal jurisdiction. Always bearing in mind that this pathway will be complex and challenging. So for victims, civil society, the path of universal jurisdictions will be long, costly, and uncertain. And while successful conviction exists, they can often take years to materialize. So that's just to show you the type of information that you will be able to find in the guide in relation of trying to assess whether universal jurisdiction is a pathway to consider given the particular incidents that you are looking at. The point of accountability through international judicial pathways, such as the ICC or the International Court of Justice, are less feasible, as it faces significant challenges in the context of Iran, primarily due to Iran's limited engagements with international human rights law in general. So, for instance, if we take the ICC, Iran is not a state party to the ICC. As a result, the ICC doesn't have jurisdictions over international crimes committed in Iran by its national, such as IRGC members. Unless Iran would consent to the jurisdiction of the court or the Security Council, would refer the situation of Iran to the ICC, which are both politically improbable. there is no way the ICC could exercise its jurisdiction over Iran. As a result, if we think of recent events such as the brutal repression of the women life freedom protests, they cannot fall under the jurisdiction of the ICC, even though they could qualify as crimes against humanity, as it was recognized by the fact-finding mission, for instance, in their last report. So civil society could try to submit Article 15 communication to try to convince the ICC prosecutor of the jurisdiction for maybe crimes committed by Iranian nationals on the territory outside of Iran, on the territory of other states parts, or use them as a way to raise awareness about the gravity of the crimes committed in Iran. But in current circumstances, the prospect of the ICC opening an investigation in relation to Iran or IRGC member is highly unlikely. Just for the sake of briefness, because I would like to leave some time for debate, the same holds true for the International Court of Justice. I'm not going to go into a lot of details, but given the low level of ratification of international human rights treaties by Iran, the accountability pathway available in relation to the International Court of Justice are really limited. There may be one or two ways to consider, but there would be very challenges, and I will leave it to you to look at it in the guide in more detail. Just to conclude, what I mostly mentioned some judicial pathway here to give you a little bit test of what you can find in the guide. It's only one piece of the broader puzzle. This guide takes a broad view on accountability and accountability pathway and address other quasi-judicial, non-judicial pathways, notably also deal with questions related to transitional justice, such as truth-seeking, reparations, and victim support, which are crucial to address accountability in Iran, given the few accountability pathways available. So obstacles to obtaining justice in relation to Iran are high. And if we want to take that path, we should not be naive about the obstacles and challenges. Otherwise, we risk to be discouraged or disappointed. It doesn't mean that we, as a community fighting for victims and justice, should not do it, but we should just plainly be aware of what to expect. So as we launch this guide, we call on all the stakeholders to use and even abuse it as a strategic and practical tool to empower victims and effectively challenge victims.
Thank you so much, Valerie, for sharing the judicial and non-judicial pathways to accountability. Due to slight time constraint, I think we might only have time for one or two questions. So if anybody does have any questions, please feel free to drop them in the Q&A box. But before we get to that, I would like to thank all of the panelists for being here today and for sharing their very powerful contributions with us. We've heard a range of very valuable insights on the pathways to accountability. And Skylar has also shared the link to the PDP project in the chat. So if anyone is interested in doing and researching more into that, the links are available to them. Yes, Skylar.
I'll just jump in briefly. Thank you, Julie. Thank you to colleagues for all of the insights. Just to highlight that I shared the link to the PDP website, which is the website that houses all of the information that I spoke about at the outset. But the report link is also at the top. There's a Persian link and also an English link. So both take you to the same website, but that's where you can find the report that we've discussed today. And yeah, we'll be circulating. It will also be available online with Uprights and on HRA's various channels later today. But yeah, we're happy to take one question. I'm conscious of everyone's time and I want to be respectful of that. So yeah. to Julie. Okay, so I don't think there's any questions. So I am just going to take this opportunity to once again thank all of the panelists, and particularly Uprights. Thank you so much for your valuable contribution to this report and always being a really great partner for HRA. Thank you also to the FFM, and another big congratulations on the renewal and extension of the mandate. It's really great for the community, for Iranians, and also for all of us doing this work. We're really looking forward to another year of this mandate, and also to redress. So I think with that, we can go ahead and close the room. Thank you, everyone.
Thank you, Karen. So good evening, everyone.
Thank you.
Record.